the constitutional validity of His Excellency Kindiki's nomination. The petitioners anchored the ground on Article 148, Sub-Article 1, read with Article 137, contending that His Excellency Kindiki was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260, at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, Sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of mid-term vacancy under Article 149, Sub-Article 1 was an independent, sui generis, executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, Sub-Article 2B, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, Sub-Article B, carves out exceptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, Sub-Article 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, Sub-Article 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, Sub-Article 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, Sub-Article 1 and Article 137, Sub-Article 2B together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, Sub-Article 1, creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, Sub-Article 1, omits the standard electoral requirements, including the signature collection requirement and Article 137, Sub-Article 1D, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, Sub-Article 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Sub-Article 2B, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as Deputy President. By severing his ties to the cabinet before assuming the Deputy Presidential office, the potential conflict of interest under Article 137, Subarticle 2B is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue,